Court is going to start court by calling Baxter County case CR 2019-10, State of Arkansas versus Chad Wallace.
How are you today, Your Honor?
Just fine. Where do we stand on Mr.
Your Honor, I talked with Mr. Wallace yesterday. We had an offer. He has since turned down that offer, but he also wanted me to bring up a possible bond reduction. He's been in there, I believe, 263 days. His bond's currently set at 10 pro, and I think he said he'd be able to make a 5 pro if that would be possible. He has no new charges. This is the only offense he's had.
Well, this is set for trial next week.
And I was going to need a continuance on that as well in order to get ready for trial.
You're newly assigned?
Yes, sir.
Okay.
Your Honor, I had a conflict of interest very late in my case, and there's nothing I could really do about that, but it's hindered me from being able to get a bond reduction or a motion to suppress the evidence because my co-defendant was also represented by Paul Bayless, Mark Cooper's constituent, so it's left me at a point where I've been in jail for a very, very long time without what I feel like is a good defense. If I could be granted a bond reduction, I could get out and better represent myself, possibly see some free days before a trial and get some work done, possibly hire a better attorney. I don't know. The possibilities are endless, but being in the situation I'm at right now, I've been in jail for a very, very long time.
Your Honor, when I spoke with him yesterday, he had also mentioned some additional discovery that I do not have in the file yet, and so I was needing the time to inquire about whether that exists or not.
Oh. Well, Mr. Wallace has raised a number of issues. The court, court is, first of all, I'm going to just say the court's disappointed that we're having to move the case to a new trial date. I'd hoped that everybody understood that we're trying to move this docket and all, but I understand Mr. Dennis, you're new on the case, but he's already disparaging the attorney he has, and it's sort of hard to move forward on a case.
Your Honor, I did not fire my attorney. My attorney withdrew on me for a conflict of interest that he found, not because I fired him.
I understand.
Okay.
But Mr. Dennis is standing here. He is your court-appointed attorney at this point.
Oh, yeah.
Okay?
Absolutely.
And he's having to move to continue your trial, which is set for next week, in order to have the opportunity to get prepared on it. And so what I'm saying is I'm a little bit frustrated right now just because of that. So we'll trying to look for a date. We've continued so many cases. They're all backed up into September, October, and November now, at the end of the year. And I don't want to keep doing that.
I'm frustrated as well.
All right.
I've been in jail for all this time.
All right. I've heard
Yes,
enough,
sir.
okay?
I'm sorry.
Just ease off. And in regard to getting a better attorney, the people we have in the Public Defender's Office right now are excellent attorneys.
Yes, Your Honor.
I don't know that you can hire people who are very much better than they are. They are extremely overworked because so many people, like yourself, apply for the public services of the public defender. We try to provide good quality service in the public defender's office, and I think the attorneys in that are excellent attorneys. Just because you have a public defender doesn't mean you don't have quality representation. I'm continuing this case to the week of for trial during the week of November 18th as an excluded period to allow for council to get prepared. I'm setting it down for a reappearance I'm going to set it down for reappearance on October 31st.
And Your Honor,
Now-
if we have a resolution before that time, I will let the court know.
All right. So that's the schedule, addressing the scheduling issues.
Thank you.
What does the state show as the bond on this case?
$10,000, Your Honor. The state feels that is sufficient, given that this is a Class Y felony offense, which is the most serious offense we have in the state of Arkansas.
It's a cash or pro bond.
It is.
Your Honor, I believe when Mr. Wallace said he could do a 5K pro bond, that in essence, he'd be a difference of $500 between the current bond and the bond he could post. And that would make it a lot easier for us to have meetings if he could actually come to the office instead of having to line up about 15 inmates and roll through them all.
Mr. Wallace, what are your connections to Baxter County?
I've been a licensed contractor in Baxter County for 5 years. I go to the Twin Lakes Home Builders Association Christmas party every year. I work for Tommy Gracie Building and Design. I have for years. I would like to get back to work, sir.
And do you have a place to live?
Absolutely not at the moment. I won't lie to you, I don't at the moment because I've lost about everything. Like I said, I've been in here for 263 days. My driver's license is a reinstatement fee away, and I have a transportation, and I have work available to me when I get out of here. I'm not used to this kind of life, so I don't know a lot of closed doors, Your Honor. I'll find a place.
Court's going to set the bond at $5,000 cash or pro.
Thank you, Your Honor.
If and when you get out, you are ordered to immediately contact the public defender's office and make an appointment and get in to see Mr. Dennis as quickly as possible.
Yes, Your Honor. Thank you very
That'll
much.
be the order of the court.
Thank you, Your Honor.
All right, you may be excused.
Thank you. You have a good day, sir.
Two 2019-174, State of Arkansas versus Dakota Druska.
Driscoll, Your Honor. We were trying to resolve this and we were not able to come to an agreement, so at this time I would say we're ready for trial.
Is there any way that I could possibly get a bond reduction so that way I could get out and have a better chance to talk with my public defender?
Well, that's not, apparently we're ready for trial, is what I've just been informed. Let's see. It's technically set for trial next week. As we all know, we've got a trial going next week set for 4 days. I'm going to move the trial date to the next available date, which that is the week of October 21st is the next available trial date. It's being moved as an excluded period based on docket congestion, and so it'll be an excluded period. The trial will be reset for the week of October 21st. I'm putting it down for a reappearance on October 17th. Now, I'll address the issue of bond. What is the bond?
It's $25,000 cash or pro.
He does have family ties to the community, Your Honor. His grandmother is actually here today, and I believe he would be staying with her if he was released.
Yes, I would be.
Is that where you were living before you were arrested?
Yes, that is where I was staying. And I've been there my whole life.
Do we know anything about his criminal history?
do believe he does have a clean criminal history. There are 14 counts of breaking and entering in this
And
case.
that's what I was looking at, is, we got 23 crimes charged, 14 of them for breaking and entering into somebody's property. That's what's charged in this matter. And I think that's the concern, and that's the reason the bond's set at a relatively high level. In this matter, the court is not going to reduce the bond. The bond seems to be appropriately set given the large number of break-ins that are alleged in this case, and statements made by Mr. Driska. So,
Yes, sir. I'm just trying to get out so that way I can get visitations with my kids and see them a little bit too.
I understand what you're trying to do, but that's not a reason in a criminal case why we set bond. So, bond to be left at $25,000. That's a cash or professional bond. You need to. I'm going to direct that your attorney get in to see you as quickly as possible, and make sure that everything that's needs to be done, preparation. I want this case disposed of by trial in October, if at all possible. In other words, I want it gotten ready for trial, and if he continues to decline the state's offers, then let's try it in October.
I will let the court know if we have a resolution, and if not, I will be ready for trial.
All right.
Thank you.
You may be excused.
Thank you.
Two 2019-354, State of Arkansas versus Michael Tolliver. I have this down for plea and arraignment today. Mr. Tolliver, have you made arrangements to be represented by an attorney?
No,
What is your intention? Are you hiring an attorney?
no,
Have you made application to the public defender?
no,
Mr. Tolliver, you're just sitting there waiting for somebody to do something about it?
no, I don't have no paperwork. I don't know what, I'm just here. Nobody's told me nothing.
Okay,
I
well,
just got the paperwork.
I'm gonna tell you this. You're charged with a criminal offense. You're charged with a
Right.
criminal offense of being in possession of a controlled substance, Schedule 1 or 2. That's a Class C felony that you're charged with.
Yes.
And you can go to the penitentiary to up to 10 years if you're convicted of that offense. I'm telling you that to say this is a serious matter. You have a constitutional right to an attorney, but it's not going to magically happen that some attorney appears. That constitutional right guarantees you the right to hire the attorney of your choice, and the courts and nobody will interfere with your hiring the attorney of your choice. If you cannot afford to hire an attorney, then you have to let somebody know that, in which case a court-appointed attorney will be arranged for. The way you let us know you do that is you ask for an application to the public defender's office. They are there at the jail. The jailers can provide them to you, but you have to initiate the action. So I'm advising you now. You said nobody told you anything. I've told you. If you want a public defender, you have to fill out and sign that application and turn it in.
Yes, sir, Your Honor. I just got it. I just got it from the jailer here.
Very good. So you after you're done here to do, make sure you fill that out. You are charged, as I told you, with a charge of possession of controlled substance, Schedule 1 or 2. That's a Class C felony. On that charge, how do you now plead?
Not guilty.
I'm writing down that you're entering a plea of not guilty, so that's on the record. Your case is assigned to my docket. I'm going to set it by scheduling order at this time for jury trial the week of January 27th of 2020. I'm setting a final hearing on that for the week of January 23rd. and then I'm going to put you down to check on attorney status in your case, and any preliminary issues that need to be taken up on October 31st. So that's all those dates that they'll be in a written scheduling order online in the file, and at this point, once you get an attorney appointed, if you stay in jail, in all probability, the attorney will be down to see you, and you can, once the public defender is assigned to the case, he'll come down and see you and get working on your case. Bond has been set in your case at this point at $5,000. That's a cash or professional bond, and if you make that bond and bond out, it'll be your responsibility by order of this court to get in touch and stay in touch with your public defender who's appointed for you. And so what that means is that if you get out of jail, it's your responsibility to contact the public defender's office and set an appointment and go in and see your attorney to discuss the case with him. He can't prepare the case if you don't get in to see him. So if you're in jail, he'll come to see you. If you're not in jail, it's your responsibility to get in touch with him. You may be excused at this time.
Yes, sir. Your Honor, I've got a parole hold. Can I still parole out?
Well, if I don't have any information in front of me that told me that, but no, if you're on a parole hold, I don't have any control over that. You're not going to be able to parole, not be able to bond out if there's a parole hold on you. If the parole hold gets lifted, or if you get assigned someplace by parole, then the bond on this case will be what controls whether you stay in jail. All right? You may be excused. 2019-200, State of Arkansas versus Brandon Brown.
Let's bring him over for the afternoon session. I think we can resolve his case this afternoon.
Okay.
Excuse me, Your Honor. I've been asking for care center for quite some time now, and I've been accepted. Is there any way we can get me in there?
Your Honor, I can.
Yeah, probably if we come over this afternoon and resolve the case. That's probably best. I get a lot of requests from people who are in jail that want to go to care ministry. Now, care ministry was out there before you ended up in jail, and a lot of people seem to think that if they go to, that's a way to deal with their criminal charges once they've been arrested. If you had a drug problem that you needed addressing, you could have been in care ministry ahead of that. So don't, what I'm saying is, the best way to do it is get this case resolved, and then and maybe make part of your resolution the care ministry's treatment program. But I will consider it as it's brought before me. But at this point, your attorney's just said if we bring you over this afternoon, perhaps we can get this matter resolved, and that's what we're going to do. So right now, I'm not going to address that issue. That's for you to talk to your attorney about. And discuss with him how to get this case resolved. You're coming over this afternoon. You may be excused for now.
Yes, sir, Your Honor. Thank you.
I have on the list 2019-368, Hannah Tolliver. I have her under that charge. I have her listed as Hannah Hope Love.
We've got her.
Ma'am, I have you down for arraignment today.
Yes, sir.
On charges of possession of drug paraphernalia, a Class D felony, possession of controlled substance, a Class D felony, driving on a suspended license, failing to present proof of insurance. Those are the charges against you. Have you made arrangements to be represented by an attorney?
No, sir, not yet.
Okay. Did
I got a call Mark Pedro.
you hear my explanation to Mr. to Mr. Tolliver about your right to an attorney?
Yes, sir.
Okay. So are you going to hire counsel, or are you applying to the public defender?
Yes, I'm going to apply to the public defender, Mark Cooper.
Okay. All right. Well, on the charges I read off, how do you now plead?
Not guilty.
I'm noting your plea of not guilty, and that you're applying to the public defender's office.
Yes, sir.
Applying. Your case is also set on my docket on those charges. I'm setting it by scheduling order for trial during the week of January 27th of 2020. I'm setting it down for a final hearing on January 23rd, and then I'm going to set you to appear on October 31st to make sure that counsel's been appointed and the matter is moving forward. At this time, I would once again advise you that if you make bond on the case.
Yeah, I have a job, and that's another thing I was thinking about getting released, because I do have a job, and I've done this work today. I'm wanting to get out and call my boss so I don't lose my job.
Well, you have a bond set on this matter of $5,000, cash or crow.
Okay.
All right.
All right, thank you.
All right. You may be excused.
Thank you. Have a
If
good
you
day.
get out, if you apply to the public defender's office and get out, make sure as soon as you get out, you contact the public defender's office and make an appointment to get in to see Mr. Cooper. All right?
Yes, sir. Yes,
All
sir, I sure will. Thank you.
That's your obligation. 2019-369, State of Arkansas versus Lakota Tripp. All right. Mr. Tripp, you're appearing at this time for purposes of arraignment on the charges against you. The charges against you are listed as break-in or entering, Class D felony, theft of property, a Class A misdemeanor, tampering with evidence, a Class D felony, theft of a credit card, 3 counts, Class D felony, fleeing in a vehicle, a Class D felony, criminal mischief in the second degree, a Class A misdemeanor, theft by receiving, a Class D felony, possession of drug paraphernalia, Class A misdemeanor, careless and hazardous driving, a misdemeanor, and no insurance, no proof of insurance. On all those charges, how do you now plead?
Not guilty.
I'm noting your plea of not guilty. Have you made any arrangements to be represented by an attorney? Huh?
No, sir.
Okay. Court's advising you have a right to an attorney, and these charges are serious, and you ought to avail yourself of that. What that means is you have the right to go out and hire the attorney of your choice. As long as you're hiring a private attorney, court's not going to get involved in any form or fashion. However, if you cannot afford to hire an attorney, you still have that right to an attorney, and the court would advise you that that you get. What that means is if you can't afford an attorney, you're entitled to have court-appointed attorney. In this jurisdiction, you acquire a court-appointed attorney by making application to the public defender's office. Those applications are there at the jail. If you want to secure an attorney, you make an application, fill it out and sign it and turn it in, and one will be appointed for you. The court is advising you further that your case is on the Division III docket of Judge Putman. I'm putting you down to appear a week from today on September 19th in front of Judge Putman. You may be excused.
Thank you.